VCEs. Today we're looking at the division of powers. First up, the division of powers and the separation of powers aren't the same thing, so don't get them confused. The division of powers refers to the way the Constitution has allocated lawmaking powers to the Commonwealth and state parliaments. There are 4 types of lawmaking powers within the division, and you need a good definition of each, as well as an example for each, to do well in this area of study. The first type is specific powers. All that means is that the power to make law on a certain area is written in the Constitution. Federal Parliament can make law in any area that is mentioned in the Constitution. For example, Section 51(1) states that Commonwealth Parliament is able to make law on trade and commerce. The second type is exclusive powers. Exclusive powers are also specific powers. They are written in the Constitution. The point of difference is that exclusive powers belong to the Commonwealth Parliament only. As the name suggests, they are exclusive to the Commonwealth. There are a couple of ways in which we can tell that a power is exclusive. The first, exclusive by nature, meaning that the lawmaking area is one that applies to Australia as a whole, and therefore it should be dealt with by the Commonwealth alone. Immigration law, for example, falls within this category. A lawmaking power might also be exclusive by prohibition, meaning that the Constitution doesn't just state that Federal Parliament can make a law on a specific issue, but it also writes that the states are not allowed to make law on the same issue. For example, Section 51(6) says that the Commonwealth can make law on defence, and Section 114 makes this power exclusive by stating that the states must not raise armies or navies. The third type, concurrent powers. They are also specific powers because they are written in the Constitution. Unlike exclusive powers, however, they belong to both federal and state parliaments. The power to make law on taxation is a concurrent one. The Commonwealth makes laws on income tax, whereas the state regulates land tax.
Hold on, Michaela. If both the federal parliament and the state parliament can make laws on the one area, what happens if they end up making conflicting legislation on the same thing?
Thanks for bringing that up. This brings us to Section 109 of the Constitution. The one thing that students don't do too well with when answering questions about the division of powers. Section 109 states that when there is conflicting legislation, the Commonwealth-made law will prevail, and the state law, to the extent of inconsistency, will be invalid. For example, states don't pass legislation changing the definition of marriage, because they know that the Commonwealth definition will always be seen as legitimate law. Finally, let's look at residual powers. Residual powers are completely unlike any other power because they are not specific. These lawmaking powers are not mentioned in the Constitution, which automatically means that they belong to the state only. That's the reason the Constitution doesn't mention some major areas for lawmaking, like crime and education. You'll need all of this information memorised, because you could be asked about any of these come exam time. Thanks for watching and happy studying.